TJ on the beat.
Well. In the good old state of Florida, a man by the name of Clarence Earl Gideon was arrested in his home and charged with felony breaking and entering. He was interrogated, blah blah blah, all the regular stuff, but this isn't the problem. The problem is about the lawyer situation. He appeared to court without a lawyer, and he requested that the court could appoint one for him since he could not afford one. But to Florida state law, an attorney could only be appointed to an indigent defendant in capital cases, whatever that means, so they didn't give him one because it was a felony case. Gideon represented himself, he was found guilty, 5 years prison, done. He ended up filing a habeas corpus relief and it got rejected. So what happened? What's the question? The question is, does the Sixth Amendment right to counsel in criminal cases extend to felony cases? Yes, it does. The Sixth Amendment guarantees the right to counsel by the 14th Amendment. In a unanimous decision authored by Justice Hugo L. Black, it basically said, to summarize it, the court of the state courts will have to appoint attorneys for defendants who cannot afford to retain counsel on their own. The court decided that the Sixth Amendment was fundamental and essential to the court and the Constitution because it was there, so it's a right people have. This impacted society by now all cases, like it or not, you're gonna have a lawyer to represent you. Ta-da. And now it's time for our next case. United States versus Mr. Nixon. So, who's Nixon? Nixon is a former U.S. president who was, mostly known for the Vietnam War, but he's also known for something called the Watergate scandal. What was the Watergate scandal? The Watergate scandal was a major political scandal from 1972 to 1974 that eventually led to Nixon's registration. What did he do? Well, he was charged with bugging his political rivals and a bunch of just dumb political stuff that was totally illegal. A grand jury returned indictments against 7 of the president's closest aides in the Watergate affair. Even the special prosecutor appointed by Nixon himself and the defendants saw audio tapes of conversations recorded by Nixon in the Oval Office. But Nixon ended up saying he was immune, and he claimed executive privilege, which is the right to withhold information from other government branches to preserve confidential communications within the executive branch or to secure the national interest. Now, what does this mean? It's a bunch of essentially dumb stuff he pulled from Judicial Review. And the question is the president's right? Is it his right? Is it to safeguard certain information using his executive privilege confidentially power entirely immune from Judicial Review? Is it immune from that? The conclusion is, well, not really. It's not. The unanimous decision, no. The court held that either the doctrine separation powers nor the generalized need for confidentiality of high-level communications without more can sustain a absolute unqualified presidential privilege. The court did kind of agree that there is a limited executive privilege in areas of military or diplomatic affairs, but they gave preference to the fundamentals demand of due process of law and the fair administration of justice. Therefore, the president must obey the order and produce the tapes and documents. Nixon did, and guess what? He shortly resigned after the release of the tapes. What did this have on society? Well, this kind of cut down the president's power a little more, and well, yeah, that's mostly it. And without further ado, the next third case is Brown versus the Board of Education.
Oh my God, boy, he got a Glock. Oh my God, boy, that boy on top. Sipping walk.
This case, out of all the other cases, has probably had the biggest impact on society. Brown versus the Board of Education wasn't necessarily a single case. It was more of like a grouping of multiple cases in states such as Kansas, South Carolina, Virginia, Delaware, and Washington, D.C. Essentially, African American students and maybe possibly other students that were not white were complaining about how segregation of schools based on race was in violation of the amendments. The specific amendment in question was the Equal Protection Clause of the 14th Amendment. Because there were so many cases of African American students being denied to certain public schools based on the laws allowing public education to be segregated just solely based on race, this court case came up essentially. In the lower courts before the Supreme Court, they were denied on the case of Plessy v. Ferguson, which held, the outcome was that racially segregated public facilities were legal so long as the facilities for blacks and white were equal. This was basically known as separate but equal, the doctrine they came out with. Doctrine, clause, I mean. So what is the question of this case? The question is, does the segregation of public education based solely on race, does this violate the Equal Protection Clause of the 4th Amendment? Well, yes, it does. And unanimous decision for Brown determined that separate but equal educational facilities for racial minorities is inherently unequal, violating the Equal Protection Clause of the 14th Amendment. So, it was violating the 14th Amendment. And how did this decision impact society? Well, it impacted society by combining black and white schools into one school. They didn't build new schools, the better school they picked at, and this standing still affects us today. Today, white and black kids go to the same school without it really doing much. Of course, racism in every area, every aspect of the world is still going to exist, but at least in schools now it is illegal to deny somebody access based on their race or whatever they believe in, all that good stuff under the 14th Amendment.